Welcome back. My name is David Nachman. I'm the managing attorney at Nachman & Associates PC, also known as the Visaserve team. We have offices in New York, New Jersey, and Canada. We handle inbound and outbound immigration law. We represent businesses and human resource managers and departments throughout the United States and the world to transfer their highly skilled labor to and from the United States. Today, what I'd like to do is I'd like to spend a little time talking to you about some different types of status that you may want to be aware of. What we have done in our office is we've generated a one-page document, which I'll show you here. It's on blue paper. If you would like to have this document sent to you, we're more than happy to do so. What this document does is it explains the two types of status that I'd like to tell you about. The first type is non-immigrant visas. The second type of status is immigrant visas, which is synonymous with green card and lawful permanent residence. Not a day goes by when an individual doesn't call us up, call our office and say, we have a person who is helping us in the home and we'd like to make them a citizen. And I say, whoa, hold on one second, you're missing a couple of steps. And what we do then is we try to go back and we try to give a potential client an idea about the way an immigration lawyer thinks and what the steps are for an individual to be able to obtain status in the United States. So there are a couple of different levels of thinking that go into that, and I'm going to share those with you today. In addition to the two types of status that are listed on that page, there are two other types of status that I'm going to tell you about. So if we were to consider that one-page document that I just showed you and two other types of status, one is off the left side of the page and one is off the right side of the page. So in going left to right, the first type of status is really sort of no status at all. And the reason why we refer to that as a status is because under Section 245I of the Life Act, which was implemented into the law in 2000 by President Clinton, if a qualified filing was made by an individual prior to April 30th of 2001, that individual is allowed, if they're in the United States and they have not departed, to obtain their green card in the United States if that green card becomes available. So what that is referred to is grandfathered under Section 245I of the Immigration and Nationality Act. And we will have a further blogging that will explain to you some of the nuances associated with that. But the most important is, what is a qualified filing? Well, a qualified filing would have been an I-130 petition for an alien relative, a labor certification application, an I-140 petition for an alien worker, an I-485 adjustment of status application, or an I-360 petition for a special immigrant. So those types of applications would potentially grandfather an individual. However, those applications need to be bona fide at the time of filing. And that's sometimes a very difficult proof because it had to be you have to show that at the time those applications were made that they were in fact bona fide. Now, moving to the right-hand side, the next type of status which I'd like to make you aware of is called non-immigrant status. And the non-immigrant visas are probably the most commonly used visas for individuals who are entering the United States. They run from A through V in the alphabet. And as you may have been able to see on the chart, we've listed out the visas. A's are for ambassadors, B's are for visitors, C's are for crewmen, D's are for individuals who are entering the United States also as crewmen, people who are working on ships. E's are for treaty traders, etc., etc., etc. And so it runs the gamut of the alphabet. And again, what we'll do is in a further blogging, we'll drill down and explain the various types of visas associated with the non-immigrant visa classification. However, the main concept that I'm hoping for you to glean today is that associated with non-immigrant visas in general is Section 214B of the Immigration and Nationality Act. Section 214B is the section that deals with what is non-immigrant intent. And obviously, non-immigrant intent means that an individual intends to depart from the United States following their temporary visit, and that they maintain a residence abroad which they do not intend to relinquish. So, for example, when we send an individual to the U.S. consulate abroad seeking a pure non-immigrant intent visa, such as, let's say, a B visa, visitor's visa, or an F visa, student visa, what we do is we tell individuals who are going to the consulate to bring documentation of their non-immigrant intent. So what is that documentation of non-immigrant intent that they can bring with them? Well, for example, what they would want to do is they want to provide documentation that they have financial ties or ties to finances abroad. They may also want to show that they have ties to property abroad, for example, a deed or a lease or something of that nature. They may also want to show that they have ties to religious communities abroad. They could also show that they have an employer in their home country who's willing to hold open their position until such time that they return home. They could also show that they have family members, extended family members in their home country to which they intend to return. So these types of things would help to demonstrate non-immigrant intent. Now, there are certain types of non-immigrant visas that are not pure non-immigrant intent visas. And those would be work visas that have associated with them what's called dual intent. Dual intent allows an individual either to stay in the United States or to leave. And those are very powerful visas. For example, the H-1B visa, which we'll discuss in a separate blogging, the O visa, the P visa, and the L intracompany transfer visa. And again, those visas will be separately discussed in additional bloggings. The next status, which we'll talk about, is immigrant visas. Immigrant visas, again, are green cards. They're commonly referred to as lawful permanent residents in the United States. That classification or that category is broken up into employment-based, family-based, and then all other programs, as it is on our chart, which, again, we'd be more than happy to provide to you. All you need to do is to email us at info@visaserve.com and ask us for a copy of our template on the blue sheet, and we'll be more than happy to provide it to you either electronically or a hard copy by mail. The last status, and again, this is off the sheet, is citizenship. And again, remember I said to you before, somebody always says, well, I have this person, they're working in my house, and I want them to be a citizen. Well, again, it doesn't work that way, because an individual can't become a citizen unless they are a lawful permanent resident for 5 years in general. There is an exception to that rule, and that is that if an individual married a U.S. citizen, then they are allowed, and if they're maintaining that same relationship, and it's a bona fide marital relationship, then they are able to obtain their naturalization 3 years from the date that they got their green card. So it's 90 days prior to the 3rd anniversary of their having the green card, whereas generally it's 5 years, 90 days prior to the 5th anniversary. And that's citizenship. And in order to obtain citizenship in the United States, there are several factors or several elements that need to be proven, and that's done on an application form N400. And again, what we're going to do is we're going to provide an additional blogging which explains how to apply for naturalization. So that's a very, very basic overview of the U.S. immigration law system that we wanted to provide to you, and so if we can be of any further assistance, please feel free to contact us at info@visaserve.com, and our Visaserve team members will, of course, do everything that we can, to assist you. Thanks very much. Bye now.